Hi, everybody. I see that everyone is coming out of the weight room. We will give just a minute or two for everyone to get in, and then we'll get started. All right, I see that we have a lot of people already here, and we have a lot to get through today, so I am going to try to get us started on time. My name is Taylor Kohler. I am the Policy and Programs Attorney here at the Center for Human Rights and Constitutional Law. And I am going to be doing the presentation today on the foundations of successful oral advocacy, along with my colleague Bartis Vakili, who is our senior litigator. If everyone could drop their question today into the Q&A, and if there are any administrative type questions, my colleague Brittany, who is labeled as tech support here, will help answer those. And if they're substantive, we will probably try to address those at the end, although Bartis may answer some of them along the way, but we'll try to get to those so that everyone can hear them at the end. Chat is disabled, so again, please drop everything into the Q&A. And we will be sending out this presentation in a follow-up email, the PowerPoint, the recording, and any helpful materials kind of referenced in here after the presentation to all the attendees, so you will get that. There will be a CLE certificate for California licensed attorneys and a certificate of participation for everybody else. And with that, I think we will get started. So just to briefly go over our agenda today, we're going to talk about the purposes of oral argument preparation, etiquette, delivery, and those component parts of oral argument. And I'm going to just kind of preface and say there is a lot of text on the screen, and that's because I wanted this to be something useful that newer attorneys will be able to reference back to. And while we might not discuss every single, bullet point today, just because of the time we have, the hope is that this will be a document you can go back and reference and use, just as a reference point while you're working on preparing for our oral argument. So we will get started today with what is the purpose of oral argument? And really, it's an opportunity to get right to the heart of the matter. It's not going to be as full and complete as your briefing, but you really want to hone in on what is that important component, and that's what you're going to bring to oral argument. And, it's important to think about when you're thinking about the purpose, like what is a judge looking for in oral argument? And so I have on this slide some of the purposes generally that judges might have for oral argument. And these are things you might want to be keeping in mind so that you're making sure to meet those needs for them. And some of those would be, it's an opportunity for judges to ask counsel to clarify their important legal, factual, or procedural points, to isolate and clarify core issues, to determine those outer limits of a position by posing hypotheticals, to clear up confusion about the facts or the record, to examine logic of the claims, and to explore consequences of their decisions. What happens if I make this decision? What else beyond just this case? And it may be an opportunity for them to argue their own particular viewpoints to their fellow judges if you're on a panel. And of course, it's also an opportunity for judges to assess a lawyer's credibility and competency. They're looking to see, is a lawyer trustworthy, open, and forthright, someone that they can trust as they go. And, as I go through this PowerPoint, I'm also just going to, at the end of slides, kind of ask Bartis. He has a lot of experience. If he has anything to kind of add to this as we go and bring a lot of those true practice pointers along the way. So, Bartis, any other thoughts on this?
Um, Nothing too, I mean, this really sort of nails the issues. I think certainly an appellate argument, judges are very conscious of the fact that they're a precedent-setting body. And so you should be ready. They, I think, will have thought about the impacts of the potential rulings. And so it's something to think about, like how narrow or how broad you want to go. At district court level, to the extent that that's something people here are concerned about, you can be a little bit more fact-based and focused and not worry about precedent. The other thing to be aware of, I think, is often, certainly at the circuit level, judges will have had a bench memo prepared for them, like highlighting the relevant law and issues, and we'll have already seen that. And so we'll have some ideas going in for some of these things. They won't always have discussed it among themselves, is what I understand, and often won't have. That happens after. They might have a sense of how the other ones might go just from working together, but it's not like they come in with a preconceived plan about how to handle these things.
So, besides the judges, what they want to get out of oral argument, there are things that advocates as lawyers that we are also, looking to get out of it. And some of those things are, this is an opportunity to crystallize, those key points in your position, really hone in on those, make sure that the judge understands them. It's an opportunity to address those factual and legal underpinnings, especially when they're more complicated. You really have an opportunity to talk to them and allow the judge to engage back with you on those complicated things. And, it's an opportunity to address questions that were, only skimmed over in briefs, really get to something. Obviously, trying to set court's concerns to rest, you may predict that they're like, hey, this decision could be much bigger than just, this case. So it's an opportunity to say, actually, this isn't as big as you think it is. It can be narrow. Here's why. And finally, it's an opportunity to demonstrate to our clients that we're committed to their cause, and we've diligently prepared, their case. And thinking about that as well. That's another objective there.
Yeah, that last one actually, I've done a lot of, well, I wouldn't say a lot, but I spent some time on an appointed panel for criminal appeals. And some of those appeals are stronger than others. And some just, you believe in the argument as a principle, but the law is not helpful. And I've had the good fortune of going back to clients who have, seen my briefs and arguments and said, you really argued, you really had my back, win or lose. That was great. And they feel seen and they feel well represented. And so, part of demonstrating to clients that the judicial system is functioning as close to as it should, as designed, is helpful and really, I think, establishes client bonds. The other thing is everyone knows who's ever written an appellate brief, certainly, or any brief, right? There's stuff that comes out. You write long and you cut. And so there's always more you want to say. You've thought about these things more than the judges have, and it's really an opportunity to demonstrate that you've thought through the impacts of the arguments that you're making. And so it's really this extra opportunity. Anytime you get oral argument, it's a good sign, I think, for your client.
So given those purposes, what are you not supposed to do at oral argument? And, it's important that it's not just a repetition of the briefs. The judges have that, so what are you bringing that is that extra bit, like Bartis said? And ideally, you shouldn't be raising new issues or abandoning claims in your oral argument. That's not the place for this. So those are just the things you're not aiming to do. And of course, as we get to how to prepare for oral argument, the answer really is prepare, prepare, prepare. And especially for new lawyers, for people who are new to oral argument, you know, it's better to do a little over preparation. And as you do it more, you will get more skilled at that, and that process may become a little bit faster. But it's simply not something that you can just rush through. It is something that you should take your time thinking through and doing intentionally and thoughtfully. So kind of one of the first steps is in this preparation stage, you're preparing for oral argument. And one of, immediately you should be thinking, who is my audience? Who is the judge that I am going to be in front of, or judges? And that means you want to make sure you understand your judge. So what do you know about the judge's existing opinions, their substantive leanings? Have they thought about this before? Um, are they knowledgeable in this area of law already? Have they done a bunch of cases like this, or is this something very new to them? And you have to perhaps do more educating on the law itself. So that's kind of the substantive component. But then also you have this question of, how does a judge typically participate in oral arguments? You might have a judge who, you know, is kind of likes to be on a hot bench, like they're going to interrupt, they want to ask questions, they want to pose hypotheticals, and they want to engage in conversation with you. And other judges may listen quietly, may be more inclined not to participate as actively. So knowing that about who you're going to be in front of can be helpful as you think about preparation. Um, and to determine this, learn about this, you can read existing opinions if they're there, talk to other legal professionals who have appeared, or worked with the judge. That might be a clerk, that might be, another attorney. As many resources as you can bring in or that you can make connection wise. Um, and of course, listen to recorded oral arguments if those are available, and possibly even just go sit in on another one, especially, if you really don't have other resources.
Yeah, one thing I do, so certainly at the Ninth Circuit level, you get your panel. I mean, this is the moment you're waiting for. You want to know who your judges are. Who your panel is a huge determinant of how your case is going to go and how you're going to present it. And you usually get it about a week or two before the argument itself, after you've briefed the case, right? And so you've briefed the case, not knowing who your judges are going to be. Now you know who the judges are going to be. I will usually by then have prepared a spreadsheet of all my cases, relevant cases, and what they've said as part of my preparation. I immediately that day, go back through all those cases and see whether any of these judges that I've been assigned to have written or signed on or dissented in any of those cases. It's really important to know what they've written on the topic. And that way you have a little bit of an insight, right? And you can use that when you go in there. So that's the very first thing I do. Even when I prepare my spreadsheet, I've taken to putting who the judges on the panel are on my spreadsheet. That was easier to go back. If they haven't, I will do, I'll also sometimes do, if I don't have something from each judge, I will sometimes do just some additional research that mimics my old research. Maybe there was a case I chose to delete or didn't cite because I had too many in my string cite, or they have written on it. So I will go back and do additional research just to get a sense of who those judges are. And then in terms of style, yes, knowing something about how they interact on the bench is really important. There's a question in the Q&A about where you can get the recordings. The Ninth Circuit, as far I haven't argued outside the Ninth, but the Ninth Circuit puts them up. Literally, if you Google Ninth Circuit oral argument video, like the first link will be a link, and then if you know the case numbers, you can sort of determine by judge. You can Google the judges. When you Google the judges, their most prominent cases will come up. And then you can go try to find that case. At the district court level, they don't tend to record, but there can be transcripts, right? And so sometimes you can go back and find practitioners in your district or cases in your district and then find those practitioners on the papers and reach out to them. So it's usually helpful to go around to people you trust, and say, hey, have you ever appeared in front of this judge or that judge? What's their style? And it just really helps in any public speaking, know your audience, right? And so that couldn't be any more true when your audience is 3 at the Ninth Circuit, or 1 at the district court level. You really want to know who they are. At the district court level, I would go sit in on, like, go look at their calendars. The calendars are publicly available, and try to make time to go sit in on some argument. If you can find them along the same substantive lines as yours, great. But at least get a sense of how they are on the bench. I made the mistake of relying on my experience and not doing that with a new judge in my district. Turned out not to be a big deal, but I didn't know he was going to do this. He came out and read a whole tentative, from the bench, a tentative ruling, and like no one in our district, very few judges in our district do that, and I didn't know he was going to do it, and I would have prepared differently. I was able to pivot because you know your issues and you're able to do that, but I would have liked to have known beforehand. So if you have the time, try to get in there and go observe. Certainly my recommendation.
So, you're also moving forward with now you're preparing for this oral argument. What does that look like? Kind of what are the steps? And we're going to try to walk through those steps for you guys today. So the first one, of course, it's obvious in many ways, but also it's good reminder. Make sure you're checking there's no changes to the law, especially you are coming and you do not want to be caught off guard if the judge says, hey, well, what about this case? You want to be on top of if something has changed that's relevant. So double checking that your law is all still good law. And then another important component that perhaps gets overlooked and that is easy to kind of trip up on because your brain is so focused on the substantive thing, but knowing the procedural standard or the standard of review, you really want to be able to articulate the standard of review applicable to the questions being presented. And there's a good chance, the judge or the judges might ask you about that. And so it's important to have thought through that, know what that is, and have a note on that so that you're prepared to answer that question if it's there, that it doesn't become something you're trying to scramble for, um, when you're so focused on the substantive issues of your case.
Yeah, you'll get that question a lot about standards. So that's something, if you're used to immigration court or you're just used to district court or state trial court level, you don't always get the what's the standard of review question. And so it's a concept. When I first started doing appellate arguments, the whole concept was foreign to me. I didn't even understand. Not only did I not understand what the standards were, I didn't understand what people were asking when they were asking me what the standards were. And so it's just like it's important to know what the different levels of review are, and to sort of familiarize yourself with that, because appellate judges certainly will hew to those standards. If you can make something about de novo review where they get to write freely, and opine freely, that legal issues like that's a big advantage. If you could have something that's pigeonholed as a factual issue and therefore gets a higher, more deferential level of review, where the judge might agree with you, but the level of deference afforded requires that they uphold the lower court ruling. That's harder, right? And so it's just good in briefing and in argument to be aware of those things. You'll often get questions about what's the appropriate standard of review for a particular question or issue.
So you've gotten those kind of base items out of the way, and now you're thinking about how am I going to put together my argument? And one of the first things you want to think about, and you may have done this in your brief, is, carried through a theory and a theme. But you want to narrow in on those and hone those even more, I think, for oral argument because you have such a short amount of time. And so the theory of the case is those legal reasons why your client should win. It's the plan, for convincing the judge or jury that your argument is right. But the theme is that moral story. It's evoking the emotional response and appealing to values and feelings. And it has to work in parallel with the theory. And you want together for these items to essentially help the court want to decide in your favor. Not only are you right on the law, your theory, but also your story is compelling. They feel like, yes, this is the right, just thing to do. Um, and so you want to be thinking about how to use your theme, and that's going to be unique and individual to what each case is going to be individual, that your client's story, but you're going to use it to frame the introduction, to contextualize your arguments and shape your conclusions. You want to be weaving that in all the way through so that when the judge says, oh, what is this case about? It's not just the law. They also have the emotion behind it, that human component.
I'd underscore that like you have the flexibility there, right? And knowing your audience. I've done cases on access to counsel for asylum seekers. And one conception and theme of the case is that these are survivors who are in a system that's Byzantine and they need help. And it's really sort of a sympathetic theme toward the struggle of such individuals. You draw a conservative panel, you might shift that, right? You might shift that to be more about fundamental fairness in judicial proceedings in general, right? Win or lose, sorry, feel bad for them or not, everyone's entitled to a fair day in court, informed by, counsel. And so those themes can tweak based on who your audience is, and so that it's important to be flexible about those things.
And so now you've thought about this theme, you've thought about your theory, and what is kind of that next step? And the next step is really to make sure you're reviewing your record. And you need to know it really well. And that means you're going to review your briefs, your key parts of your record appendix, findings, conclusions, key pleadings, all of it. And then after you reviewed it, do it again. Go back to those super important components and think about how does the entirety of what you have fit together? How, are how did your record, the documents, how do they fit as a big picture so that you can think about that? If a judge asks you a question about that, relate it back to something that you think is important. Um, and then, of course, within your record, knowing your key authorities, your rules, your statutes, your cases, you really want to know by heart those core ones, specifically the ones you're relying on or that the opposing party may be relying on. Um, and it's important to think about while you're reviewing these, how do they support your argument and how may opposing counsel, use them to undercut your argument, being prepared for that. And not just getting focused on yours, but knowing you might have a question on something that opposing counsel relied on. And then, of course, knowing your facts, you want to be prepared to highlight the ones that strengthen your case and be able to acknowledge and neutralize those that weaken it. You don't need to pretend that they don't exist, but have a plan for why the judge should think they're not that important, why they aren't determinative. And you want to know the location in the record for those key facts, the factual reasons why your client either wins or loses, and the facts that you relied on in your brief or that you plan on relying on for your oral argument.
Yeah, and I would reread all your cases, the substantive ones. We've all been in this, well, I've certainly many times been in the situation where in the government's cases too, I've been in the situation where I'll read the government's brief and be like, oh, man, they're gonna win. And then you go to read the case and they've cherry picked a quote that doesn't really expand upon the law as much as it implies, right? The rest of the case says something else. And the same can be said of your own cases in the heat of a briefing deadline. You might have relied on something and there's bad language later. And so it's just good to reread everything and know your sources. On the facts, I do that. It's a little like thing that I like to do is I'll often have record citations in my little outline, and I'll drop one or two during the argument just to signal to the bench, I know my record, right? I know where this is. Sometimes when you're lucky, you'll get the judge actually flip. They'll have the record in front of them, and sometimes they'll flip to where you've pointed them. So it's just little things you can do to go back to that point Taylor made earlier, like letting the judge know you know your stuff. Little things like don't overdo it, right? And like cite every page of everything, but dropping a little cite here and there. Different for case cites. I wouldn't repeat case citations. I wouldn't go in there and say, the Gomez case, F23rd, F52, F3rd, whatever. They have the cites. Um, but for the record, I think it's useful.
So then you've reviewed your, all of your documents again, and now you're preparing those essential arguments. What are the arguments that you want to make? And it's important to remember there is a time limit for oral argument, and that is going to restrict which arguments you decide to put forth. And you should be selective, and you really only want to choose 2 to 3 essential arguments. When you expand that beyond, you bring in all your arguments, it means you're not going to have a chance to make them strong, right? You're stretching yourself too thin, and that isn't what you want to do, especially if the judge ends up asking questions or, using up some of your time that you're answering things that you didn't plan on answering. Now you might not have a chance to present your strongest argument. So it's important to be thoughtful, be intentional with selecting the arguments that you're going to make. A helpful guide about thinking what are the essential arguments, what are the things that I want to hone in on are the arguments that you have to win to prevail in your case. An argument that you expect opposing party to make on a critical issue that you have to overcome to win your case. Or an argument that you expect the judges to be particularly interested in or have questions about. Something that you've reviewed everything about your judge and you're like, I know they're going to ask about this. They're going to think this is really important. So you're going to be ahead of, game on that.
Just like a rule of thumb, very, very rule of thumb, very flexible. But I will generally go 5 minutes per argument. In my mind, I'll prepare. If I've been given 10 minutes, I'm walking in with a plan to argue 2 things. That doesn't mean if the judges want to go in a different direction, that you go where the judges want to go. But that's my plan. If I get 15 minutes, I might throw a third one in there. If I have 20 minutes, I might throw a fourth one in there. But you really, to Taylor's point, you don't want to, wise man, my old legal director, David Lloyd, to give him credit, always repeated in my head, fight where you're strong, not where you're weak, right? So you want to go in with your strongest arguments and really hammer them. That should be the plan. Whether the judges take you in a different direction is a different question, but that should generally be the plan you walk in with.
So once you have, determined what those essential arguments are, you're going to think about putting those together, the theory, the theme, and those essential arguments, and how can you use them together to explain your case and, the arguments all in a compelling way that, again, creates the fact that the judge wants to rule in your favor. So thinking about crafting your argument, you have that opening statement and you want to hit hard right away. You don't want to hide the ball, Here's where I am. And so you should articulate your theme right away. Immediately pull in, the judge to your story that you're telling. And ideally that's going to be in your first or second sentence. So think about getting your theme out fast. And then as far as your arguments that you've decided on, you want to lead with your strongest argument first. Ideally, you have all strong arguments, but sometimes you may not. So you're going to pick your strongest first and then work your way down. And then within each of those arguments, you're going to start with your strongest points. And while you're preparing this and thinking about it, it's useful to think about what are all the important points. So think through all of them and identify those. But then you're going to need to distill them back to the key points. What are the ones that are most important? But it's still useful to spend the time thinking through what are all the points I have here in support. And then you also want to spend some time identifying those counter arguments to your opposing party's arguments. You do want to be prepared to address your weakest point. Assume you're going to be asked about it or you're going to be pressed on that. What do you want to be able to say? And again, thinking about that theory and theme, You want to be correct on the law, but also framing your case so that you are seeking a just and fair result. That's something that appeals to the bench.
And just, I'll chime in with one quick thing here on the opening statement, right? You never know when you're going to get interrupted. Um, I've gone once in where it was a completely cold bench and I got to do my whole argument, and it was a signal that they were waiting to hear from the other side. They had questions for the other side, not for me, which was a good sign. But most of the time, they have questions. They want to get into them. They're going to give you a little bit of professional courtesy to get your opener out. But if they sense that you're sort of not jumping into the substance of the argument, they'll interrupt you. So whatever's the important themes you want to get them out quick. Not quick, like talking fast, but plan to state them early in your presentation.
Some additional considerations while you're thinking about your preparation as well, and you want to plan for these. These might be questions that you get asked. So what is your prepared like response? What do you think is coming? Might be some limiting principles. What are the limiting principles that could prevent unintended consequences of ruling in your favor? Especially if you predict that the judge or the bench that you have, that you think they might be concerned with that. Think about, if they jump to this conclusion, what can I say that says, actually, don't worry, we're not going to have those consequences. We can deal with it. Thinking about how to backstop your argument. If a judge completely disagrees with one position, how can you say, well, even if you disagree with this, we should still win? And so having a plan for that, again, hopefully you don't get there, but being prepared with that answer helps you if you do get asked something like that. And then also predicting some of those questions that you might be asked. And that comes with knowing your case closely, knowing your opposing counsel's arguments, knowing the judge, and if you've reviewed, their past experience or past opinions, what are they interested in? And that'll help you think through the questions. But it's useful to take the time to think through these. Don't just assume, oh, I will be able to answer. I know my case. Of course, but taking the time to think through those and prep those answers will make you so much more prepared if you do get asked them. So you've done all of that, and now you need to kind of create your outline. And an outline is the organizational tool that helps you put together a checklist to ensure your essential arguments are covered. And it's really important that you design it to be flexible enough to adapt to, the bench and the judge that you have. You may have, like Barta said, a completely cold bench, and you're going to be able to go through everything you want. Or, much more likely, you're going to be interrupted and you need to move through something, quickly, or skip an argument because of time that you had wanted to get to, but you're like, well, that one's out. I need to focus on what's most important to this case. So you want to design it with that flexibility in mind so that you can move easily to different sections or quickly get to a section where it might be something that you have on a question you predict. How can I quickly look and find that, to be able to answer a judge's question? It's important that you don't use your outline as an opportunity to write out an entire speech or a script. You're going to be looking down then, and you have a tendency to read it, which prevents you from kind of engaging with the court, making eye contact. And it's hard to get back to the correct point. If you get stopped and asked a question, now you were in the middle of a speech, and how do you, get back to that or smoothly transition? So even though it may feel helpful to do that, it isn't. You want to think about this outline being short and concise. Ideally, it's 2 pages. It's something to help as a reference point for you to get to those core arguments. No more than 4. Typically, it can be helpful to staple, your pages into a file folder. Some attorneys attach note cards with just like the case information on the inside of the folder. Use bullet points, headers to clearly demarcate your topics. Use what's useful to you. There isn't a strict way to do this, but think about it like I can glance down and find what I'm looking for. Um, you don't want to be searching and shuffling pages and trying to find something. Um, and it's important to make sure in your outline that you do have your introduction. That might be a place where you have a little bit more preparation because you're going to say you want it to be clear, and it's unlikely, hopefully, that you get interrupted right out of the gate. And you'll have a roadmap, which is important to share with, and we'll discuss this a little bit further on, but um, it's the essential arguments you're going to address and the conclusion you want the court to draw. And you want to give this to the judges to tell them where you're going and why. It helps them see the path. And then maybe also they won't, interrupt you with a question that they know you're going to answer in another minute or two, which helps you. But just give them something to know. Here's what I'm going to tell you. Your introduction and roadmap, those are things you should try to kind of have memorized. Maybe not word for word, but pretty close. You want to know what you're saying there, and have that really be nailed down.
That's totally right. And this is the hardest, most stressful part for new attorneys. New to oral argument is getting comfortable not having a script. But it really, really helps. Again, to give credit where it's due to the mentors that taught me, um, Joanna Schiavone in San Diego is one of the, Mary Lehman, they've all sort of said repeatedly to me, that 2 to 4 page limit is what you want. You don't have time you don't want the judges seeing you flipping through pages. You don't have time to get to more that's in like 2 to 4 pages. I've been taught, and this worked for me, like I literally staple my arguments into like I can't see this, like a file folder. And that way I just have something I can flip to without being too distracting. And then I do exactly what Taylor said, color coding, fonts, sizes, something so I can glance down, remind myself of what I want to say, and then glance back up and say what I want to say. I can catch it quickly, and go back up. I also think of them as not an outline, but like modules, right? Because a judge might take you by question to like your third point right out of the box. And then so now you're in what I would say module 3, right? You hit all your points. Now you're done. If you can glance down and look and see, all right, well, now I can pivot back to module 1, which is what I wanted to say. It's easier than if you have it like in a binder with like 12 pages of notes.
So once you have all of these things together, you've thought about your judge, you've crafted your arguments, you've reviewed your record, you've made your outline, you have to practice. Practice, practice, practice again. And you're going to do this alone a bit. You're going to practice in front of a mirror. You're going to watch the habits that none of us like to see about ourselves, and you're going to try to correct those. But of course, practicing by yourself is going to help you commit the structure of the argument to memory. Thinking about, okay, I want to make this argument, and these are the points. And so that's helpful to do that by yourself. But then it's also important that you're taking the time to do that in front of others. And ideally, you have a chance to actually moot your argument. And I know, especially with legal aid attorneys, everyone is so busy. It is really hard to, make the time to moot the case, but it's important to actually moot it. Don't just sit around the table and discuss it. That's not the same thing. It's helpful, but it's not the same as actually practicing it, practicing being interrupted, and having to do that under some pressure. So I'd really encourage everyone to try to make time in our very busy lives that is more beneficial than just having a conversation about it. You will gain a lot more by actually being able to do it as if you're doing it for real. It helps you practice, being interrupted. It helps you practice with your time. Nerves, right? You still have nerves when you're presenting to your colleagues, on that. So, and by practicing, you have the opportunity to narrow down those most essential arguments and points. You realize, like, oh, actually, I don't have as much time as maybe I thought I did. I might have to chop off this point because it's not as essential. And it can help you identify, like, what are the points where people are getting confused when you're mooting this in front of, your colleagues or friends? Where are they stuck? And they're like, actually, we didn't understand the argument you were making. That gives you a chance to reflect and go, okay, I need to explain this better. I might need a little bit more time to explain this topic. And it's really important that I explain this, so I want to get rid of something else. Or alternatively, you're like, this is too complicated. It's not that critical to my case. And actually, I should abandon it because we might get stuck down a rabbit hole trying to explain this and waste time where I could be better served somewhere else. So use that to hear and get that feedback from other people and think about how to edit your argument to fit within the allotted time.
I like practicing out loud is absolutely critical. It even just training your mouth to say the things, right? Like you've thought them all, you've written them all, but training your mouth to say the sequence of words you want to say, it's like a skit, like you have to do it. My family knows when I have an oral argument coming up, right? They're like, oh man, dad's pacing around the room talking to himself again, right? Like it's just getting it out, hearing it really matters. How am I going to say non-refoulement? Am I going to try non-refoulement? Am I good? Like, what am I going to do here? Right? Like, just um, that helps. And with the mooting, if you moot well, you'll very rarely get a question from the bench that you haven't already gotten in a good moot. I'll often invite people that were not involved in the case to moot, right? We're all wonks on our particular issues, right? Like if I do an asylum appeal, it's an issue I know better than any other, right? I don't want just asylum wonks in my moot. I want to know where the arguments I've made assume too much about the knowledge of my audience, right? These judges are not wonks on any particular, I mean, they might be, but usually not on your issue. They're generalists. And so that kind of feedback's really, really critical of where you might be missing things and just practicing the answers um, and getting that kind of feedback, really being open. It's a vulnerable place to put yourself, but it improves the product so much.
So then after all of that, it's also important to make sure that you also have time to review any local rules or practices, that you might not be familiar with, or it's just your first time in that court. So make sure you spend a moment familiarizing yourself with the local rules and practices. There might be some rules or conventions around, the format of oral argument or the timing, that you're unfamiliar with, especially if you're new, you're probably unfamiliar with all of it. So just read through that. It, helps you have that information, make sure that you're prepared, something doesn't happen that you didn't expect. Well, as much as you can that you didn't, expect to happen. And sometimes there's unique customs of a court, like there might be a court custom that out of state counsel, has to be introduced by a local lawyer. So it's just small things you should take the time to review. And then something that can really help calm nerves, and I'm a big proponent of this, is like do a test run if you're able to, visit the courthouse if you haven't been there before. Find the courtroom where the hearing is going to take place. If you have a chance, like observe the dynamics of that courtroom, see how the docket is called there. Locate, where if I need to talk to a client or where, if I need to prepare something, where can I go? Is there a space, for me to sit down for a second? Physically go through those processes because then those things aren't the things making you nervous on actual oral argument day, right? You can actually take your brain and sorry, my dog. Bartitz, can you finish this slide?
Yes, yeah. So on the just the test run. So just know the things that you need to know. Is there going to be in the Ninth Circuit? Is there going to be a light um, that goes off? How does that work? You can usually call the court and find out things like that. Um, know that drive. Know that drive at the traffic hours that you have to make that drive. So little things like that. You'll take so much stress out of your life if you know the logistics of what's going to happen, and you can just focus on the substance. So, make the drive, know the parking, ask around, do all that stuff so that on the morning of, you are not freaking out because you're also late and you also don't know what the metal detector situation is, whether you're allowed to bring in water bottles. And that's the stuff that you can try to get ahead of by calling ahead, talking to practitioners, things like that.
So just some basics now to cover around etiquette for your oral argument. Of course, one of the things is to present a poised and professional appearance, um, and acknowledging that, especially for women, people of color, there may be some extra anxieties around that, and acknowledging that, having some space for that, and doing your best to show up in a way that the court is going to see you as a professional. Um, ensure that you are on time. Be early, be prepared, don't be late. Leave with lots of extra time, especially someone like me who always makes the wrong turn, inevitably. Um, use formalities when addressing the court, avoid slang, avoid, you know, just be professional in that sense. Very important, never interrupt a judge or show frustration or become defensive. You want to maintain your composure even when you're angry inside and frustrated. It's showing respect for the court and also confidence in your position. You're not getting flustered. You're not, losing your cool. You believe that you're right and that you have a winning position. And along those same lines, make sure that, as soon as a judge begins to ask a question, stop speaking. Don't try to finish your thought and hope, just stop, pause, you know, give that due respect to the judge. And then some components of the actual delivery of your argument and how, you effectively convey your message. Your message can be incredible, but it's important that you deliver it in a way that all that work that you've put in is effective. So of course, one of the biggest things, I think we all know this, but it's harder done than said, is trying to speak at a normal pace, not being too fast or too slow. And again, I think that gets back to the practice, practice, practice. If you're doing it out loud, you're able to see, your speaking pace more so. So making sure you're speaking at a normal pace, also making sure you're speaking up and not getting quiet when you're nervous. You don't want the judge to have to interrupt you and say they can't hear you. Then if you're already nervous and you're speaking quiet, then you're caught off guard by that. So just try to speak loudly, not yelling. You also want to try not to fidget, don't be shaking a pen around or, bouncing on your feet if you can. It ultimately ends up distracting from the message you're trying to get across. You want to try to make eye contact as much as possible. Adapting gracefully to the court's interests. You have all these arguments you want to make, and the judge may have a completely different idea and they want to go off and talk about this. You want to make sure you're, addressing the court's interests. And ideally you weave back in your themes as you go and try to redirect where possible, but be respectful to the judge has questions and you want to make sure that you are reassuring them and getting to some of those things that they might think are really important. And finally, don't give up just because you feel like, the judge doesn't like your position or, you perceive some hostility. Don't give up in your position. Keep being, an effective advocate for your client.
Never concede anything on the record in an argument. Just don't do it. You won't have time to have thought it through. Just fall back on your position. Just say, stand by the position in the briefs. Don't. Too often you see people. So would you respond to, so would you concede this? I mean, I'm not going to say never, obviously, but don't feel cornered.
So now we're going to kind of go through, as we're short on time, but I think, I want to try to get through, these oral argument delivery components.
And
So
Taylor, I'm sort of crushing the Q&A in writing, so you have a little bit of extra time.
excellent. Um, so we have, the first thing that you are going to be doing is your introduction and your roadmap. And you want to introduce yourself, your client, the matter before the court, and the relief your client is requesting. Um, and then once you have done that, um, if you are introducing the appellant, you want to reserve time for rebuttal. And how much time you reserve is going to be dependent on how much time you have overall. Bartis, do you have thoughts on a great practice for how much rebuttal you typically reserve?
It based on the minutes I've been assigned, but never more than 3, really. I mean, you're on the rebuttal, you're going to want to hit 1 or 2 main points. But usually you'll have anticipated and done in your opening.
Yeah. And then, so you've done those formal introductions, you've reserved your time for rebuttal. And then this is where we talked about you want to immediately get to the essence of your case, utilizing your theme and that succinct and persuasive statement. Right away, you're tuning the judge into here's what this case is actually about. It's about justice. It's about, the rule of law. It's about, protecting women from violence. It's about whatever that is. You immediately want the judge to switch into that framework. Um, and then you're also going to give your roadmap, which again is that summary of your argument and the order in which you plan for the argument to progress. And it's straightforward, but you want to give that to the court. Tell them how you're going to structure things.
It's actually really huge. Today I'd like to discuss point 1, point 2, point 3. They'll hear right away whether you're going to get to something they have a concern about, or you should grant because of A, B, and C. It's just good to signal that roadmap.
And then we have kind of facts. Generally, in most federal appellate courts, you can assume the judges do have a basic knowledge of the facts and history, but it can be helpful to present the facts in a compelling manner for your case. How much you do that or not is, discretion on your part, but there's kind of 3 ways you can think about doing this. One of them, and it's perhaps the simplest, but not always the most persuasive, is to present them kind of after that introduction and roadmap and before your argument, thinking about framing. And then you could also do it integrated into your introduction. So while you're explaining that theme, you're weaving those facts in. This is a case about violence, protecting women from violence, and then you're adding those facts in there. It could also go into your roadmap. Here are the things I'm going to talk about. And as part of your arguments that you're saying you're going to talk about, you're also bolstering them with a key few facts. And then we have the argument itself. Just like we thought about earlier, you're going to present your arguments around your strongest issues first. And you're going to present those most compelling supporting points for each of those first as well. And you want to think about, when you're presenting these arguments, making affirmative statements about why your client wins first. I win for my reasons. And then you can address the shortcomings of your opposing counsel's argument. You don't want to ignore those arguments entirely, especially if they're particularly strong arguments or you think the judge is going to think they're strong arguments, but you don't want those to be the first thing you say. Throughout all of your arguments, as we've been covering throughout this training, you want to be advancing your theme. You're weaving that into each thing you say so that the judge is never losing track of the big picture, the moral issue, whatever that is. As Bartis has shared, like, it is important to make sure to get to your major points, right? It may be the only opportunity you have. So again, don't hide the ball. Like, lead with what you need to say because you could get cut off with a string of questions. And that's why it's important to present your arguments, strongest issues first, most important points first, because at any point we could end up in questions. And after you finish one issue, you can proceed directly to the next. You don't need to pause or solicit questions. The judge will interrupt you and ask if they have them. And then finally, kind of for your conclusion, this is your opportunity to tell the judges what you said. You want to reiterate what the client is requesting, why the court should grant that, and make sure you're revisiting your theme. You're bringing that home again. You do want to aim to timely conclude because it lets you wrap up and have that final word in the way you wanted to. So it's important to think about that, even if you have to, cut short a supporting point you might have had above. If you don't think it's that important, maybe you'd rather finish that 1-2 sentences, concluding and wrapping everything up. But if you are still speaking when your time runs out, you should immediately stop speaking. And you have to ask the court if you can finish your thought or briefly conclude. And it's really important that you don't take advantage of that generosity. Do not continue on to point 1, point 2 that I wanted to fit in. Finish your thought, just that thought, thank the court, and retire. The judges do not like if you take advantage of that and continue on, add multiple minutes. That is not what they want you to do. So just once you finish your conclusion or you run out of time, thank the court and sit down. And then we'll get to, answering questions, which is always going to be a challenge. It is a challenge. And so because of that, it's really important to listen to the questions being asked carefully. What is the real concern that the judge is trying to, express? And you shouldn't assume a question is hostile. Like, don't make that assumption or jump to that. The big thing for questions is you need to answer questions immediately, directly, and concisely. And if a judge is asking a yes or no question, answer it, and then add the explanation in which you're trying to limit or qualify that. If you don't know the answer, and sometimes you may not, just admit it, offer to submit it to the court in a letter the next day or to get that, information to them. It's worse to struggle along and potentially provide information that's inaccurate. Also, you're using time where you're trying to answer something you don't know that like you would be better off getting to the points you wanted to make. So just the better answer is to, sorry, sorry, Your Honor, I don't have, that citation in front of me, but I'm happy to get it for you and submit it to the court. And finally, avoid the temptation to dodge the tough questions. It's better to just answer them, embrace them, show why you still win. When responding, make sure that you try to look at the judge who asked the question, make eye contact, that's that respect component. And you want to answer questions in a professional and conversational tone. You don't want to be combative. You want the judge to see you as an asset in their search for the right answer. They're asking you a question because they're trying to get somewhere. So, maintain your professional demeanor even under intense questioning.
You'll hear it from anyone who's done argument, that the answer and then explained, you got to do it. You just cannot. They'll see you trying to by meander around and avoid the question. And maybe the only thing you can do with most judges to really anger them. So just answer, you can do things like, well, Your Honor, like obviously you're thinking through your answer, you can do little stalls, but while you articulate, but the first substantive thing out of your mouth should probably be yes, but, or no, but, or it depends on this, but in this situation, yes, like it's got to be an answer and then an explanation.
And then finally, just briefly covering the rebuttal. Typically, the appellant will have time for rebuttal. As Bardis said, you're going to base that on how much overall time you have, but typically not more than 3 minutes. You want to take advantage of the opportunity by responding to only the major points raised. And you should think big picture about this. You should be trying to read a judge's responses to opposing counsel's arguments. What was the thing the judge you saw appeared to be positively responding to? That might be something you want to actually try to rebut. So be really strategic in choosing, the one or two, probably one, point that you're going to try to make. For your rebuttal, you'll begin with an abbreviated introduction. Tell the court how many points will be addressed. Again, this helps them to differentiate, especially in a short amount of time. I'm saying this, and then I'm going to say this. You're going to briefly state the point that the respondent or the appellee made, and then tell the court why that argument is incorrect. Make sure not to use your rebuttal to raise arguments that you didn't have time for in your original argument. That's not the place. The court won't appreciate that. Make sure you're actually using it to rebut something.
Yeah, a good rebuttal in my a good rebuttal is like hammer one thing, hammer two things, get out, right? Like it's not a you're not really. This is why what they just said is wrong on this issue. This is why what they just said is wrong on that issue. When you're picking which ones to pick, you want to pay attention to things that maybe have their panel split, right? Maybe there's something where it felt like one judge was with you and one judge wasn't. You want to lock in that judge that might have been with you, right? Or that third vote. If you know one's against you, you got to lock in that second vote. So that's sort of what you think about when you're trying to figure out, they just made a mess of all my argument, the opposing side. Which two things, three things am I going to go after?
And so that kind of wraps us up. That is, a high level overview of, approaching oral argument. I know we're a little short on time, but Bardis, were there any questions that maybe we should try to?
No, I got to them in writing. There was a couple of requests for some written materials that I'll circle with you and we'll prepare and we'll get around to folks. Just examples of what an outline, what a module outline can look like and what the case spreadsheet can look like. We can put those together.
Excellent. So then in that case, a link to the recording and copies of the PowerPoint will be sent to everyone here in a follow-up email later this week. Bardis and I will try to get together some additional helpful materials that he just mentioned. Again, CLE credit will be submitted for California attorneys who provided their bar number when registering, and all other attendees will receive a certificate of participation. If you have any questions, you can reach out to me. My email is on the slide. And otherwise, thank you so much for being here. We hope this was helpful. We welcome all feedback, so please, there will be an evaluation form. Please take the time to fill that out. We really do appreciate it. Or, you're also welcome to just email me and share your thoughts as we develop our training programs. We really like to get that information. And otherwise, thank you so much. Bye, everyone.